wanted to ask you about using those electronic I-9 generation and storage systems. Now, they're not absolved of their liability, right? In an audit, an employer is not going to say, well, I use this system, great, so these errors that are made, or if there are any system limitations, is that going to get them some mercy or?
Well, no, it's not.
Welcome to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. The United States is many things: a great melting pot, a nation of immigrants, a land of opportunity. Millions have journeyed here seeking freedom and the chance for a better life. Belief in the American ideal means providing opportunities for everyone, regardless of race or birthplace, to achieve their highest potential. Join us as we unravel the ins and outs of immigration policy, from the issues of today to the historic basis for laws already in place.
Welcome back, everyone. Thank you for joining us again. Elise and I are now going to pick it back up and continue our discussion about I-9 compliance and protocols to strengthen your program. Another really important topic that I wanted to talk a little bit about is reverification, right?
Okay.
And I have seen where, again, employers think of it as onboarding paperwork. We did the I-9, their work authorized, we filed it away, fine. How does reverification come into play? And what are the obligations and responsibilities there?
Okay. So re-verification is all the more important now, particularly with all of the new developments in immigration. So re-verification means that any employer who does an I-9 must re-verify that I-9 if the employment authorization is expiring. And they must re-verify that I-9 before the expiration date of the employment authorization. So, for example, if someone has an employment authorization document that is expiring, the employer must go back before that expiration date and re-verify. Another example is if someone has an I-94 related to a work authorized visa that's expiring, the employer must go back before that period. The government says that employers are supposed to look at Section 1, where the employee says employment authorized until date. So you look at that date as well as the documentation to determine the date to re-verify. But bottom line, you need to re-verify before the work authorization expires. To re-verify, the employer must ask for any combination of documents again that show work authorization. So what documents is that? I think a lot of employers get confused because they think it's the whole list again, right? I need a list A and a combination of B and C. That's not it. So remember, you already verified their identity. So you just need the work authorization. The work authorization is either a list A document or a list C document. So you need one or the other. I think another pitfall that employers get into with re-verification is they say, just give me your new whatever you had, right? If they provided an employment authorization document, the employer says, oh, did you get this extended? Give me the new one, right? But they might have some other basis for employment authorization. So it's any list A or a list C. Other tips for re-verification. It's really important for employers to have a good tickler system for re-verification where they have a reminder to re-verify before the expiration date. I also recommend that the employer not only have an internal tickler system, but they reach out to the employee and say, hey, we have your I-9. We see that your work authorization is expiring. You need to bring us documentation before this date, on or before this date. Historically, I think we've recommended that notification to the employee 90 or 120 days in advance because things were getting approved. There were allowances under the law. If you filed an application, you may get continued employment authorization. I am now working with employers and suggesting that that notice go to employees as much as 180 days in advance. And you may say, that's crazy. It's 6 months in advance. But there's a reason I'm saying 180 days. I'm saying 180 days because usually that is the mark when the employee can file a document asking for an extension, either of time limited work authorization with a work authorized visa or for an employment authorization document. All the more important now to kind of ping the employee because except for a STEM OPT extension, there is no longer the option for employees who file to extend their employment authorization document to show the employer in any EAD that they filed for the extension, right? There's no auto extensions anymore. So I think the 180-day mark really makes sense to notify the employee. And if the employee isn't thinking of it, hopefully it jogs them and they're like, gee, I need to apply.
Right. And I think this also brings us back to that point of training, right? Because in the last few years, we've seen so much about this auto extension of EAD. It was 180 days, 540 days. Now there's no extension except for something, right? So I think having this training and keeping up to date is critical. Also, I wanted to ask you about your thoughts and tips on using those electronic I-9 generation and storage systems. Now, I still like paper and I've done I-9 audits on paper and I found it to be a little bit easier just to look at the paper. But of course, as you know, as the world evolves and we're all using technology, there are ways where, you know, through ADP or through other systems, right, that are commonly used in the HR world, the employee can complete their section, they can sign their I-9, then the employer completes it. It doesn't look like an I-9. You're just clicking through boxes, you're looking at the documents, and then it generates an I-9. And then there's an electronic audit trail. So you're not actually marking anything, and that's where it's stored. Now, what are your, you know, top tips for employers to think about? Because they're not absolved of their liability, right? In an audit, an employer is not going to say, well, I use this system, great, you know, so these errors that are made, or if there are any system limitations, you know, I did my best. Is that going to get them some mercy or?
Well, no, it's not. So, and that's a really good point, Natalia, because I think it's very important for employers to vet the electronic I-9 systems. And it's really interesting. It doesn't absolve them of liability. In fact, if you look at the contracts with the electronic I-9 providers, none of them provide indemnification. And the government still fines even if you have an electronic I-9 system. One of the leading cases on electronic I-9s was Abercrombie and Fitch. You probably remember that case. The fine was over $1 million. And the government press release on it was very interesting. It was very clear that the fine related to the electronic I-9 system, right? And what happened in Abercrombie and Fitch is the electronic I-9 system produced an I-9, but it did not mirror the government's I-9. The fine actually, because I know some of the attorneys that worked on that case could have been a lot higher. That was a resolved fine of over $1 million for Abercrombie and Fitch. So they really were working to fine on each and every I-9. So that is an extreme error, but there's other errors that we're seeing with certain I-9 systems. There are some I-9 systems where, and particularly this happens when it's a free add-on. I think when more and more people started using E-Verify, HR systems and HR providers basically said, wow, these employers are using E-Verify, and employers want an electronic I-9 system that's just going to feed right into E-Verify. And to make our HR system more attractive to employers, we need to have this feature. But it was not really a focus. It was kind of an add-on to the system, and maybe there was no charge for it. With some of those systems, not all, we find that it was an add-on that's not updated when the I-9s are updated. It's not compliant with the law. They don't have internal resources with some of these add-on systems to make sure that the systems actually follow the regulations. I've seen some electronic systems where they actually force an error. So there's one electronic system, for example, that won't allow the employer to complete the I-9 if there isn't a Social Security number. So you may say, well, but wait a minute, this is an employer who uses E-Verify. I know if you use E-Verify, you need the Social Security number. But remember, the I-9 and E-Verify are separate.
Right.
You can hold on the E-Verify if you don't have the Social Security number, but you still need to do the I-9 in a timely fashion.
Right.
So there's little things like that that you need to look at with the electronic systems. Other issues are, does the electronic system have an option for you to audit the I-9s? How do you audit and correct the I-9s? How do you upload the documents? And if you get that notice of inspection that says you need to produce everything in 72 hours, are they going to be able to give you everything? And are they going to be able to give you all the I-9s? Are they going to be able to give you the audit trail? And is the system compliant? And Natalia, I'll let you speak to this because you did the article on the new guidance that took out the virtue memo. But I think another concern is whether or not your E-Verify system or electronic I-9 system that feeds in is going to cause substantive violations.
Right, because with this new updated guidance, certain errors relating to the e-signature, right? Because if you're doing it electronically, there's an e-signature, and also this audit trail that you've been talking about, right? Where to say, well, who reviewed it? How was it fixed? Those are now going to be potentially considered substantive errors.
Right.
So understanding the capabilities of the e-signatures and these audit trails is really critical in selecting a system, because I know when I've looked at audits and I've looked at these audit trails, I mean, they're extensive, right? And you could see who opened the file, the I-9, who viewed it, who made the correction, why was the correction made? And that's really critical, especially if there's going to be, a discussion or an argument about whether it's a substantive error or not.
Right.
You briefly mentioned E-Verify, and we're going to have a whole separate episode on E-Verify and everything that's involved with E-Verify and desk audits. But Elise, is E-Verify a substitute for an I-9? And how does it all play into I-9 compliance?
So it's not a substitute for an I-9. I think a lot of people think, oh, I'm using E-Verify. That's all I need to do. I got an employment authorized result from E-Verify. I'm home free. I'm not going to have any fines. I'm okay. Not so, right? They're still going to look at the underlying I-9s. E-Verify and the I-9 process are still separate. Even if you have an employment authorized result under E-Verify, you could be fined on your I-9s. So they play in together very closely. I think E-Verify, a lot of employers and more employers have adopted E-Verify. And there are benefits of E-Verify, right? If you want to do a STEM OPT extension, for example, you need to use E-Verify, right? So, and it's not mandated federally, but we're seeing more employers use E-Verify. There are certain downsides to E-Verify. I think there's pros and cons, right? The downside to E-Verify is there is a compliance and monitoring branch that literally sits with the E-Verify team, and they review records. And they often share information with IER. And the government's also using more AI now. So they're looking for patterns, and they can look for patterns within the E-Verify electronic system in terms of what documents employers accept, what the employer is doing. We have seen a number of IER audits triggered by the compliance and monitoring branch because they looked at the E-Verify records. And usually you'll see the IER audit notice come in saying something like, we think that you are requiring all US citizens to provide a passport, or we think that you're specifically requiring permanent residents to produce a permanent resident card versus any acceptable combination of documents. So if you do use E-Verify, there's a couple of things I recommend. Number one, do a self audit before you start doing E-Verify. Do training after that self audit, and make sure you have a good compliance program that includes basic I-9 training and reinforce the non-discrimination requirements before rolling out E-Verify. There are benefits to E-Verify. While E-Verify cannot detect document fraud necessarily or document abuse, because E-Verify is simply running the numbers in most cases, right? If it actually has a valid number, it could be a stolen document, right? So that's a downside. But if the employer has done their job and the document, at least on its face, appears reasonably genuine and to relate to the employee, and they have an E-Verify result that's employment authorized, it may still provide some protection. But remember, it's not full protection just because you get that employment authorized result. The government could say, for example, yes, you used E-Verify, but we still think there's a pattern or practice of unauthorized employment. So I'll give you an example. The Asplund case. The Asplund case from a couple of years ago, the Asplund company actually used E-Verify. And the government fined the Asplund company. It was the largest fine ever. It was $95 million. So I actually was on a panel a couple of years ago with the lead auditor who brought forward the Asplund case. I still remember we talked about the case, and I was talking to him and I said, well, wait a minute, explain to me how this happened. Because it's my understanding they used E-Verify. How in the world did it get to the point where they really had this pattern and practice of unauthorized employment? So what he explained was that the company was very decentralized, and there would be a feeder system of employees that were using fraudulent documents. And the fraudulent documents often would still go through E-Verify. So it's not a full protection. Yeah, it's pretty incredible. $95 million to a company that was using E-Verify. But the government was able to prove there that there were some individuals at the company that set up this decentralized process, as well as word of mouth hiring, that allowed the employees who were not authorized or found not to be authorized to move between the various parts of the company.
Wow. Yeah, I definitely, reading that case, it was very interesting to understand how their I-9 system worked and what protocols they had, and maybe some things that not to do.
Definitely things not to do.
It was definitely a significant fine. So as we wrap up Actually, since we talked about fines,
Yeah.
what I wanted to wrap up with is to summarize everything that we've talked about today. And again, looking at it through the lens of an I-9 audit. So once the agent reviews all the documents, they propose a fine. In that fine negotiation, there are some things, right, that the employer can argue and can rely on to hopefully get a decreased fine.
Yes.
And I want to bring that back to, well, how do you build a strong protocol, and what are the things that employers can do practically from day one to then be able to show if they're audited 10 years later
Right.
and say, well, look at all these things that we've been doing. We've been showing good faith, right?
Right.
So can you just wrap us up and talk
Yeah.
about those few things?
So yes, and I think it's there's two levels here. So when an employer receives a fine after a notice of inspection, we're often brought in, and sometimes we're brought in when we haven't been involved at all, right? I'll give you an example of a case. So I had a case where the employer was fined $250,000, and they produced I-9s, and I'm looking at the documentation, and I'm saying, I really don't understand it, because it looks like you produced documents on, the very first day, and you continued to produce documents, but the government didn't credit all the documents that you handed over. And the employer said to me, well, he was such a nice officer. He came and he said, don't worry about this. You can hand over to me whatever you have now. And as you find things, you can kind of add to the pile. And I'm like, well, wait a minute. No, they're not counting this. So I think first tip is the officer may be very nice, and they genuinely may be a nice person, but at the end of the day, the government is going to look at the notice of inspection rules and the 3 days. And unless you have an extension in writing, they may not accept the documents that were produced later. Now, I was I was able to find enough information suggesting that the company relied on these extensions to challenge the fine and to allow the additional documents that came in, and also challenge the findings on the I-9s themselves, where I was able to say, no, this I-9 actually was proper. So the first step is the fine even valid, right? The second step is, how do you set up a program and argue this fine should be reduced based upon the discretionary factors? So there's 5 discretionary factors that can allow for a minimum 25% reduction. So it's size of the employer, as you said, good faith of the employer, right? Whether there's unauthorized aliens, is there a history of violations, right? It's all of these things that the government is going to look at to see, can you reduce the fine? So if you have a program, you've got a good I-9 policy, you regularly do training, you use E-Verify, you keep all of your information, that goes a long way to reducing the fine. Also, if at the end of the day, the employees are not unauthorized. In that case that I was talking about, the 250,000 fine, I was able to work to negotiate the ultimate fine down to $10,000. So a couple of things I argued were, it was good faith. They really were trying to do the right job. There were absolutely no unauthorized employees. So good faith, absolutely no unauthorized employees. It was basically paperwork violation for 250,000. They'd never been audited before. And the $250,000 fine literally would have bankrupted the company, because the company was in a sector that was doing badly. And it was one of the largest employers in the area. And we documented how if this company goes under, it's going to impact that town. So all of those factors we used to reduce a $250,000+ fine to $10,000.
Well, I think this really illustrates how a one-page form carries potentially such significant liabilities and ramifications for not only the employer, but the employees and potentially the larger communities. Well, Elise, thank you so much for joining us for this
Thank you, Natalia.
episode. It's been really interesting discussing all these nuances of I-9 compliance. And to our listeners, tune in to the next episode where we'll be doing an even deeper dive into I-9 audits, the mechanics of how they work, and how to approach those audits with the government. And if you have any questions, we invite you to schedule a consultation with us, sign up for our newsletters, follow us on social media as we continue to monitor these developments in an increasingly serious enforcement environment. Thank you again, and have a great day.
Thank you for listening to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. For more information, visit us at klaskolaw.com. Follow us on LinkedIn, Instagram, and Facebook. You can email your immigration questions to podcast@klaskolaw.com. The materials contained in this podcast does not constitute direct legal advice and is for informational purposes only. An attorney-client relationship is not created by listening to or accessing this podcast. The information provided should never replace informed counsel regarding specific immigration matters.